News. Take care of Maya. Shocking twist. $200 million verdict overturned today. $261 million verdict to be exact. The appeals court overturned the verdict and ordered a new trial today. So we're going to go over the papers today, over the documents that were submitted. Actually, they were submitted on the 29th. So we're going to check that out and see what's going on and see what's going to happen for this family because their nightmare saga continues. Sounds like they're going to have to go through an entire trial again. And if I remember correctly, the last one was like 3 months long, I think, maybe a little more. So we're going to get into the documents and see what's going on. It's terrible. It's awful. This family's been through enough. And of course, when you fight a hospital, you fight corporate America, any kind of big corporation, you're going to lose. And they've got money out the ears that they can spend, that they can just throw at this and throw at this and throw at this. And your average citizen can't do that. So it's really turned into a shit show. And I really feel terrible for this family, especially Maya. So let's get into the papers and check it out and see what we're checking out here. So this comes from the District Court of Appeal of Florida, 2nd District. John Hopkins All Children's Hospital, which is the appellant, versus Maya Kowalski and Jack Kowalski individually and as personal representative of the estate of Beata Kowalski, who is deceased, are the appellees. October 29th, 2025. Appeal from the Circuit Court for Sarasota County. Hunter W. Carroll was the judge. Derek M. Steichleather, Carrie J. Williams, and M. Peggy Chu of Goodell, DeVries, Leach, and Dan, LLP, Baltimore, Maryland. Chris Aldeburn of Banker Lopez Gasler, PA, Tampa, and Eleanor H. Sills of Banker Lopez Gasler, PA, Tallahassee, for appellant. Christine R. Davis of Davis Appeals, PLLC, St. Petersburg, for Amici Curie, the American Academy of Pediatrics and the Children's Hospital Association. Andrew S. Bolin of Bolin Law Group, Tampa, for Amicus Curie, Florida Hospital Association. Michael G. Tanner, Kenneth B. Bell, and Justin T. DeLeese of Gunster. Yoakley and Stewart, PA, Jacksonville. Gregory A. Anderson and Jennifer C. Anderson of Anderson Glen, LLP, Jacksonville. Selden J. Childers. And Nicholas P. Whitney of Childers Law, LLC, Gainesville, substituted as counsel for record. And Raymond T. Elliott Jr. and Amy S. Ferrier of Buell, Elliott, Ferrier, and Faircloth, PA, Tampa, for appellees. If you guys haven't been following this case, if I remember correctly, Greg Anderson and Nick Whitney had a falling out shortly after the trial. I believe it was over some money and where money was going and how it was being spent or something along those lines. Some sketchy acts by Greg, according to Nick, allegedly. So there was apparently a falling out as far as I know. And looking down here, it says Selden J. Childers and Nicholas P. Whitney of Childers Law, LLC, Gainesville, substituted as counsel for record. So if I remember correctly, I think she decided to keep Nick as her lawyer or something like that. I could be wrong. Black, judge. John Hopkins All Children's Hospital, Inc., JHatch, appeals from the final judgment rendered against it and in favor of Maya Kowalski, Jack Kowalski, and the estate of Beata Kowalski. Collectively, the Kowalskis. The final judgment awarded damages to the Kowalskis for false imprisonment between October 7th and October 13th, 2016. Intentional infliction of emotional distress, wrongful death for intentional infliction of emotional distress, false imprisonment between October 18th and October 20th, 2016, false imprisonment on January 6th, 2017, medical negligence, battery on January 6th, 2017, battery for unspecified dates, and fraudulent billing. The trial court's erroneous interpretation and application of Section 39.203, subsection 1A, Florida Statutes 2016, and the immunity afforded thereunder, as well as the trial court's erroneous denial of J. Hatch's motions for directed verdicts and J. Hatch's motion for a new trial, require reversal of the final judgment. 1. Background. In the fall of 2015, Maya Kowalski was diagnosed with CRPS, complex regional pain syndrome. Beata Kowalski, Maya's mother and a nurse infusionist, became aware of CRPS prior to Maya's diagnosis through one of Mrs. Kowalski's patients. CRPS is a central nervous system disorder. It is characterized by severe regional pain with no apparent cause. Patients with CRPS experience an array of symptoms, including agonizing pain in the affected region or limb, extreme sensitivity to touch, light sensitivity, and lesions. Next page. Initial treatments for Maya's CRPS included warm water therapy, physical therapy, non-narcotic pain medications, and opioids. When the initial treatments failed to relieve Maya's pain and symptoms, Maya began receiving ketamine. This included Mrs. Kowalski taking Maya to Mexico, where Maya was placed in a 5-day ketamine coma for a period of approximately 8 months prior to her admission to JHatch in October 2016. Maya was being treated with ketamine infusions through a central venous port in her chest. The ketamine infusions were authorized and overseen by Dr. Ashraf Hanna, a pain management doctor. Although ketamine had been the longest used and most successful treatment for Maya's CRPS prior to her admission to JHatch, Maya's physicians had also prescribed other treatments, including hyperbaric oxygen and immune system stimulants. During most, if not the entirety, of her treatment, Maya was unable to walk without assistance and was in a wheelchair. On the day before Maya's admission to JHatch, Dr. Hanna advised Mrs. Kowalski that he had given Maya the maximum dosage of ketamine that could be administered and that it was not helping Maya. Dr. Hanna advised that Maya be taken to JHatch. Footnote 1. Dr. Hanna did not testify at trial. On October 7, 2016, Mr. Kowalski brought Maya, then 10 years old, to the emergency room of JHatch. Maya presented with excruciating pain. Upon Mrs. Kowalski's arrival at JHatch, she was adamant that Maya received ketamine infusions, and although JHatch was able to confirm with Dr. Hanna that Maya had been in his care and had been receiving high dosages of ketamine, the hospital emergency room notes state that dosages at the level demanded by Mrs. Kowalski could not be administered in the ER. Next page. Maya was ultimately admitted to the Pediatric Intensive Care Unit at JHatch, PICU. Concerned about Mrs. Kowalski's demands for ketamine and perceived consistencies between Mrs. Kowalski's recitation of Maya's medical history and JHatch's own observations, a social worker at JHatch, in accordance with JHatch policy, called the Department of Children and Families Abuse line on October 7, 2016. The following day, October 8, 2016, JHatch contacted Dr. Sally Smith because of the suspected abuse. Dr. Smith, who had privileges at JHatch, is a pediatrician and was the medical director of the child protection team for Pinellas County at that time. Footnote 2. Child protective teams are used to supplement the assessment and protective supervision activities of the department. Section 39.303, subsection 3. On October 9, 2016, a second call from a social worker at JHatch was made to the Department Child Abuse Hotline. The second call resulted in an immediate investigation. On October 13, 2016, Maya remained at JHatch but was taken into the department's custody. The department filed a dependency shelter petition requesting that Maya be placed in the shelter care of the department because Maya had been abused, abandoned, or neglected, or was in imminent danger of abuse, abandonment, or neglect. The department sought medical shelter care for Maya and requested no contact between Maya and Mrs. Kowalski, but supervised visits between Maya and Mr. Kowalski and Maya's brother. On October 14, 2016, following a hearing on the department's petition, Maya was placed in the shelter care of the department. The dependency court order provided that Mrs. Kowalski was to have no contact with Maya pending psychological evaluations of both Mrs. Kowalski and Maya. The order further provided that the department would make all efforts to identify an appropriate person at JHatch to supervise visitations between Mr. Kowalski and Maya. Additionally, the order provided that in the event Maya's parents were unwilling, the department or the person primarily responsible of the care management of Maya was authorized to consent to ordinary and necessary medical examination and treatment of Maya. Footnote 3. Footnote 3 says Section 39.01, subsection 43, defined necessary medical treatment as the care which is necessary within a reasonable degree of medical certainty to prevent the deterioration of a child's condition or to alleviate immediate pain of a child. Let's see, where was I at here? Okay. Thus, as of October 13th, 2016, Maya was in the custody of the department, and beginning on October 14th, 2016, Maya was under the jurisdiction of the dependency court. At trial, Mr. Kowalski testified that at some point between October 8th and 13th, 2016, he and Mrs. Kowalski requested that Maya be released from J. Hatch, and that J. Hatch subsequently threatened them with arrest if Maya were to leave the hospital against medical advice. Mr. Kowalski testified that J. Hatch advised him that Maya could not leave the hospital because Maya had to be safely weaned off medications, including ketamine. Evidence at trial established that J. Hatch attempted to transfer Maya to another hospital, but that the Kowalskis would not consent to the transfer because the insurance code on the transfer form indicated that Maya had Munchausen syndrome or conversion disorder, or was the target of Munchausen syndrome by proxy, and did not indicate that Maya was suffering with CRPS. Mr. Kowalski testified that he and Mrs. Kowalski would not sign the transfer form because they believed it would mean admitting guilt or blame. Subsection 4. 4. Evidence established that prior to Maya's admission to J. Hatch in October 2016, concerns had been raised about psychological factors affecting Maya's physical condition by medical professionals who had treated Maya at Tampa General Hospital and Lurie Children's Hospital of Chicago. Back up here at the top. Without referencing the limitations and requirements of the dependency court orders, Mr. Kowalski testified that anything that he brought into the hospital had to be approved, whether it was clothing, food, or letters. Food was required to be prepackaged and could not be homemade. Mr. Kowalski testified that during one of his visits, Maya had asked him whether Mrs. Kowalski was in a mental institution. When Mr. Kowalski asked why Maya would say that, Maya told him that a J. Hatch social worker assigned to Maya, Catherine Beatty, had told Maya that Mrs. Kowalski was receiving mental health treatment. Mr. Kowalski testified to additional statements made to him by Maya, including instances where nurses had told Maya that her illness was all in her head, and where Miss Beatty had told Maya that she could be Maya's mother while Maya is there at the hospital. I remember that. That was terrible. That was absolutely awful of that woman, and she testified to that. Mr. Kowalski also testified regarding his own interaction with Miss Beatty, wherein she asked him, "Did you ever consider divorcing your wife?" He responded, "What are you talking about?" And Miss Beatty said, "Oh, forget it," and walked away. Mr. Kowalski relayed to Mrs. Kowalski what had happened during his visits with Maya and the information he had learned. Although he was aware that Maya had been moved to a new room on October 18, 2016, Mr. Kowalski testified that he was unaware that the new room, identified by J. Hatch staff as the EEG room, was under video surveillance until many years after the fact. He testified that he never saw Maya mistreated. Likewise, he never saw nurses taking actions that he considered to be cold or unusual. Maya testified at the trial that the commode in the EEG room was far enough from the bed that she would have to stand up and walk to use it, which she could not do. Maya believed that the nurses wanted to provoke her in order to prove that she could walk. Maya testified that she was not permitted to speak with her mother and that this infuriated her. Although Maya was told that her pain was in her head and that she was making it up, Maya testified that she was not told that the physicians believed she had conversion disorder or Munchausen syndrome. One instance Maya relayed involved a specific nurse verbally accosting her for not moving during a bed change. Despite Maya advising the nurse that she could not walk, stand, or roll, the nurse said, "If you don't move right now or else." She recalled that nurse yelled at her for quite a while, saying, "I know you can move. I know you're faking it. Just stand up. We all know." What a great nurse, man. Got in the nurse field to help people, huh? The Kowalskis are Catholic, and Maya testified that she was not permitted to receive communion from her parish priest. She did receive communion from a priest associated with J. Hatch. Maya believed the outside food, including the community wafer, was not permitted because there was a fear that Miss Kowalski would tamper with it or somehow add ketamine to it. She did not testify to the requirements of the dependency court orders in this regard. Maya reiterated in her own testimony that Miss Beatty had told her that Mrs. Kowalski was in a mental institution. Maya quickly learned that Miss Beatty's statement was false, and Maya believed the statement was intended to manipulate Maya into thinking that her mother was sick and therefore making Maya sick. Maya also reiterated that Miss Beatty told her, "I'm not trying to be your mother, but I can be." Mrs. Kowalski was born in Poland, and Maya often spoke in Polish with her mother before her admission to J Hatch. Although the dependency court eventually permitted Miss Kowalski to have supervised phone and FaceTime calls with Maya, Maya was not permitted to speak Polish with her mother, and the calls were limited to basic and insignificant things. An audio recording was played of one conversation wherein a female voice advised Mrs. Kowalski that we are not allowed to talk about the dependency case, after Miss Kowalski told Maya that as soon as the judge makes the decision, she would be able to see Maya again. Footnote 6. Maya recalled that this was Miss Beatty redirecting the conversation. However, J Hatch introduced into evidence an email from Charlotte Laporte, a department social worker assigned to Maya's case, stating that Miss Laporte redirected Mrs. Kowalski during that conversation. I'll be the first to sit here and tell you, I watched that entire trial, and let me tell you, it was Kathy Beatty. Okay, it was not this Charlotte Laporte. Okay, it was literally the same voice, 100%. Charlotte Laporte also testified, so we knew what her voice sounded like. So we know who it was. It was Kathy Beatty on that recording. Okay. A final instance involving Miss Beatty, occurred when Miss Beatty took photographs of Maya before Maya left the hospital for a dependency court hearing on January 6, 2017. Maya testified that Miss Beatty came to Maya's room and told Maya that if Maya wanted to go to court, she was going to have to be stripped naked and photographed. Miss Beatty and a nurse did photograph Maya before court. Maya was wearing a training bra and shorts in the photographs. She understood that the photos were for purposes of the dependency case. Maya testified that she was in worse condition when she was released from J Hatch in January 2017 than when she was admitted. She also testified that by her 7th and 8th grade years in school, August 2018 through May of 2020, she was participating in physical activities without restrictions. Ms. Beatty's deposition, I do have to say this. It is strange how she did get better, though, after her mother's passing. She got all the way better. Really, really better. Now, I watched the trial. I didn't think that it was a Munchausen by proxy case. Obviously, I'm not a professional, but that's just my personal opinion. I could be wrong, but that's just my personal opinion. She was just an overbearing Polish Catholic woman. I don't think that she had any intent to do harm to her child. And Jack, the husband, the dad, he just obeyed his wife. His wife was a nurse. She was an infusion nurse. So she knew what she was doing, and he thought the same thing. So he let her do what she did. Okay. Ms. Beatty's deposition was played for the jury. She testified that she was a licensed clinical social worker at J Hatch at the time of Maya's admission. Ms. Beatty testified that she was required to follow the dependency court shelter orders and that it was the dependency court that determined who Maya could see and when. She also testified that court orders provided general parameters. I'll be right back. Sorry, the kids were trying to get in here. All right. So I'll start back. Miss Beatty's deposition was played for the jury. She testified that she was a licensed clinical social worker at J Hatch at the time of Maya's admission. Miss Beatty testified that she was required to follow the dependency court shelter orders and that it was the dependency court that determined who Maya could see and when. She also testified that court orders provided general parameters, but that the department in J Hatch, to some extent, determined how to implement those parameters. Ms. Beatty testified that she was required to follow the dependency court shelter orders and that it was the dependency court that determined who Maya could see and when. She also testified that court orders provided general parameters, but that the department in J Hatch, to some extent, determined how to implement those parameters. Yeah, the risk team. Ms. Beatty testified concerning the initial calls to the Department Abuse Hotline and the rationale behind those calls. Footnote 7. Much of Ms. Beatty's testimony concerned actions authorized or required by Chapter 39 and responses to questions mischaracterizing J. Hatch's continued involvement as taking this child away from her parents. She also testified that 95% of the time that she saw Maya was up in her wheelchair. In the times that she would report extraordinary pain would be when she was prompted by her mother, or if somebody asked her if she was having pain. She further testified that J. Hatch noted on several occasions where Maya was moving her legs, moving her hands without any pain. Maya was engaging in activities such as foosball, cutting out and making crafts in the craft room. She was out playing the piano downstairs and often moved herself around the hospital. It was only after we gave that information to the department that Maya then decided or quit moving herself around the hospital for a few days. In one of her case notes, Ms. Beatty wrote, Maya told me she was furious, angry, and in pain. She told me she can't talk or trust anyone, that she knows there is court on Monday, and it's all lies. Ms. Beatty testified that J. Hatch has a policy against recording phone calls, and that she therefore objected to Mrs. Kowalski recording calls with Ms. Beatty. She also testified that whether Maya was permitted to see her priest was up to the dependency court. Ms. Beatty testified the department asked that J. Hatch monitor Maya's calls, and that at times calls came through Ms. Beatty's phone, and she would put her phone on speaker to allow Maya to have the conversation. Ms. Beatty supervised phone calls between Maya and Mrs. Kowalski once the dependency court authorized supervised limited contact. At no time did the dependency court authorize in-person visitation between Maya and Mrs. Kowalski. That is 100% a fact. This poor girl never seen her mother again, ever. After she went to that hospital, and I think she was there for maybe a day or two, maybe 3, and then they took her into state custody. She never seen her mother again because her mother was never given physical visitations again. Her mother unalived herself before that ever happened because she was going through so much from the dependency court and the hospital not allowing her to see her child and everything else that was going on with it. I'm going to go over this trial again. Now that this has happened, I'm going to go over this trial again on this channel. I think we're going to watch that entire trial again, or at least the most important witnesses, because this is a big deal. This is a really big deal. All right, let's see. Okay. Ms. Beatty testified that in January 2017, J. Hatch's risk management department asked Ms. Beatty and another person to take photographs of Maya before she was taken to a January 6th dependency court hearing. The request for photographs had been made by an attending physician at J. Hatch. Ms. Beatty testified that in the professional context and in the foster care program, photographs are taken if there are injuries. She confirmed that at the time of the photographs, Maya was in the custody of the department and that the department was getting ready to take their own pictures as well. No one explained to Ms. Beatty why she was taking photographs of Maya. Ms. Beatty noted that the email she received addressed concerns that Maya was self-mutilating and had scratches on her body. On January 6, 2017, the dependency court ordered that Maya would remain sheltered at J. Hatch and set a February 2017 trial date. Mrs. Kowalski unalived herself the following day, January 7, 2017, leaving 2 notes. Those notes reflect Mrs. Kowalski's sadness and frustration with the dependency court proceedings and those involved with the dependency proceedings, including J. Hatch, the department, and Dr. Sally Smith. That woman is evil. 100% evil. It takes one look at her in 10 minutes of her testimony. She's evil. We're going to go over her testimony too. 1 week after Mrs. Kowalski's suicide on January 13, 2017, the dependency court allowed Maya to be released from J. Hatch and to resume living with Mr. Kowalski. Does that right there throw red flags up to you? because it does to me. 1 week after the mother unalives herself, the state, the dependency court, all of a sudden allows her to go home. I mean, what? All because you just assumed and thought and think you diagnosed Munchausen by proxy? I mean, that's absolutely insanity. This poor girl, this man, this father, this husband, and their brother, her brother, Kyle Kowalski, lost their mother. Them two children lost their precious mother. They'll never get her back. I mean, it's just absolutely astonishing, that these corporations do this. But at the same time, we know it's greed. That's all these corporations are. It's just a big greed fest. They don't care about her. It's all about money. This Dr. Sally Smith, the Child and Family Services in Florida is privatized. It's not a state-run organization like it is in Michigan. In Michigan, we have CPS, and it's a government entity. In Florida, it's privatized. So they make money off of every case they get. They make money. They make more money. Then they need the doctor to do the case. So Dr. Sally Smith is going to 100% fabricate cases so that she can make money. Why wouldn't she? She literally is a privatized doctor for the state. So the state pays her. It's a bunch of free money. And this is all through the state of Florida. Florida is known for Department of Child and Families, DCF, to overrun these families and just make up lies, take children. I mean, this is the biggest trafficking organization you've ever heard of. I'm not kidding. DCF, CPS, all of those child protective services type organizations are awful. They're terrible. And these people, I don't know how they sleep at night, but they do. They do. All right, let's carry on. So after the mother passed away, a week later, she was released and allowed to resume living with her father. The dependency case was ultimately dismissed. Imagine that. During the months that Maya was sheltered at JHatch, she was weaned off ketamine, and the dependency court order releasing Maya from JHatch prohibited additional ketamine treatments. Maya had been admitted to JHatch in severe pain, unable to walk, and receiving high doses of ketamine. When she was discharged from JHatch, she was still in significant pain and unable to walk. At the time of trial, the only medications she routinely took were Claritin, Flonase, and a sleep aid. She had been able to walk, run, and ice skate. Maya testified that she had experienced no CRPS flare-ups in the 3 years following her January 2017 discharge from JHatch. I'm getting hot. So the Kowalskis filed their lawsuit on October 5th, 2018. The operative 8th Amendment amended complaint was filed on January 24th, 2023. More than 50 pretrial motions were litigated and resolved before this legally complex and emotionally charged case was heard by a jury beginning on September 14th, 2023. During the 2-month trial, 2-month trial, additional motions were filed and resolved, including multiple motions for directed verdicts. On November 9th, 2023, the jury returned a verdict in favor of the Kowalskis on all remaining claims. Post-verdict, JHatch filed an omnibus, renewed motion for directed verdict, motion for a new trial, and motion for a remediator. The court then entered the final judgment. 2. Analysis. A. Standards of review. Issues of statutory interpretation are reviewed de novo. MKV Department of Child and Families 380 SO 3D 469 472. Florida's 4th District Court of Appeals 2023, citing BY versus Department of Child and Families. Florida 2004. A trial court's decision on a motion for directed verdict presents a question of law. The sufficiency of a party's evidence that we review de novo Kim v. Jung Hyun Chang, Florida, 2nd DCA 2018. When considering whether the trial court should have granted a directed verdict, we must evaluate the testimony in the light most favorable to the non-moving party, and every reasonable inference deduced from the evidence must be indulged in favor of the non-moving party. So, in the party of the hospital. So the non-moving party is the hospital. That's Winter Haven Hospital, Inc. versus Lyles, Florida 2nd DCA 2014. Our review of the denial of a motion for new trial is for an abuse of discretion. Edwards v. Rosen, Florida 2nd DCA 2016. In reviewing an order on a motion for a new trial, an appellate court should consider the totality of all errors and improprieties. All right. Immunity. Section 39203. Pretrial. J. Hatch moved for partial summary judgment based on the immunity afforded pursuant to Section 39203, subsection 1A. J. Hatch argued, as relevant to this appeal, that every claim against it, except the battery claims, was precluded as a matter of law because J. Hatch had reasonable cause to report suspected child abuse and was otherwise participating in Chapter 39 proceedings. The trial court granted in part and denied in part the motion based on its interpretation and application of Section 39203, subsection 1A, to the Kowalski's claims. J. Hatch argued in its post-verdict motions that a new trial is warranted based on the trial court's narrow interpretation and erroneous application of the statutory immunity. On appeal, J. Hatch again seeks a new trial based on the court's erroneous rulings with regard to Section 39203, 1A, and their pervasive impact on the trial. The trial court considered two sections of Chapter 39 and applicable precedent addressing the statutory language. Section 39201, subsection 1A, which they talked about all the time in court, or in the trial. Chapter 39, that's Chapter 39. And that's what they were always referring to. Section 39201, subsection 1A addresses mandatory reporting of child abuse and provides, in relevant part, any person who knows or has reasonable cause to suspect that a child is abused, abandoned, or neglected by a parent shall report such knowledge or suspicion to the department in the manner prescribed by subsection 2. Physicians, nurses, and hospital personnel engaged in the admission, examination, care, or treatment of persons, as well as other health or mental health professionals, are required to provide their names to the abuse hotline when making a report. 39201, subsection 1D, 1 through 2, suspected child abuse by a parent must be reported immediately. And footnote 8, notably, the department also bears responsibility under Section 39201. And any person who is required to report known or suspected child abuse and who fails to do so commits a felony. So it's a felony if you don't report child abuse. Section 39203, subsection 1A addresses actions authorized or required by Chapter 39, as well as reporting child abuse, and provides any person, official, or institution participating in good faith in any act authorized or required by this chapter, or reporting in good faith any instance of child abuse, abandonment, or neglect to the department or any law enforcement agency shall be immune from any civil or criminal liability which might otherwise result by a reason of such action. So basically, they have immunity as long as they are reporting it in good faith and it's not out of revenge or, get backs. As long as there's good faith and they reported it in good faith, because I don't want to catch a felony and I'm suspecting that this child's being abused by Munchausen by proxy, then I have to report this or I'm going to go to jail. So that's what Dr. Sally Smith was doing when she reported it. Allegedly. In construing Section 39201, subsection 1A, the trial court also considered Urquhart versus Helmick, 947 SO 2D 539, Florida 1st DCA 2006, and Ross versus Blank, Florida 4th DCA 2007. Both cases address only reports of suspected child abuse and the immunity afforded thereto. In Urquhart, the court concluded that there are two ways in which a doctor can be immune from civil liability for making an incorrect report of child abuse. Immunity exists as a matter of law if the doctor has reasonable cause to suspect that the child has been abused and makes a report of the abuse as required by law. In that event, there is no need to determine whether the doctor acted in good faith. Once reasonable cause has been shown, a reporter complying with the statutory mandate to make a report is by definition operating in good faith. However, the absence of reasonable cause does not prove liability. It merely removes the immunity that would otherwise apply as a matter of law. If the objective evidence does not support a conclusion that the doctor had reasonable cause to make the report, the doctor may nevertheless claim immunity from civil liability by showing that the report was made in good faith. If it appears that the immediate safety or well-being of a child is endangered, that the family may flee, or the child will be unavailable for purposes of conducting a child protective investigation, or that the facts otherwise so warrant, the department shall commence an investigation immediately, regardless of the time of day or night. In all other child abuse, abandonment, or neglect cases, the child protective investigation shall be commenced within 24 hours after receipt of the report. Okay, let's see. Citing your court, the court and Ross likewise concluded that if a reasonable basis existed to report child abuse, the motive in making the report is irrelevant. Based on the facts before it and the above cited precedent, the trial court determined very easily that J. Hatch had reasonable cause to report suspected child abuse to the department hotline. Accordingly, the trial court found that J. Hatch was entitled to Section 39203, subsection 1A, immunity from any civil claim which might otherwise result by reason of the reports. But the court said nothing of immunity for claims resulting from participation in good faith in any act authorized or required by Chapter 39. The facts of this case are unusual in that the reporter, for purposes of Section 39201 and 39203, remained a participant in Maya's care beyond the initial shelter hearing and was required to comply with the dependency court orders by virtue of the department designating Maya's placement with J. Hatch. I'm going to read this footnote real quick. Footnote 9. The trial court expressed trepidation in applying the Urquhart analysis insofar as Urquhart concluded that the immunity that is afforded to a medical doctor is not the same as that afforded to an ordinary citizen. Well, okay. Yeah. Where neither Section 39201 nor Section 39203 differentiate between doctors and ordinary citizens, except that the former are required to give their names when making a report, while the latter may remain anonymous. While we might agree with the trial court on that narrow issue, application of the statutory immunity as between doctors and ordinary citizens is not before us. As the shelter placement, J. Hatch was required to implement the dependency court orders. Those orders required J. Hatch to comply with visitation guidelines set forth in the orders, as well as to manage correspondence between Maya and Mrs. Kowalski. Footnote 10. The dependency court orders included directives on screening visitors through the department and who specifically would be permitted visitation. Moreover, the orders directed that the court would not micromanage or countermand J. Hatch's policies. In that absent clear and compelling reasons, J. Hatch's staff was to be free to address the medical needs of their patients without the court, the parents, or others interfering with their professional judgment. J. Hatch was required to take part in the sheltering of Maya by virtue of the shelter order entered October 14, 2016. The department sought to have Maya sheltered based on ongoing abuse and imminent danger. The dependency court sheltered Maya, and the department was authorized to determine her placement. The department placed Maya at J. Hatch for ongoing medical treatment, including psychological evaluation and weaning off ketamine. I mean, she was on a lot of ketamine. I mean, even the doctor in Mexico, which they have much different regulations than we do. The doctor in Mexico told her, I can't do this anymore. I can't give her any more ketamine. She's at the highest dose possible. And Dr. Hannah told her that. I don't think he's the doctor from Mexico. I can't remember for sure. Yeah, I think he is a doctor from Mexico. But yeah, Dr. Hannah said she can't get no more. Got to go to J Hatch. All right, let's see. Within the text of Chapter 39, the legislature established its intent expressly. The purposes of this chapter are to provide for the care, safety, and protection of children and to prevent the occurrence of child abuse, neglect, and abandonment. The legislature further stated its intent that Chapter 39 be liberally interpreted and construed in conformity with its declared purposes. Courts may not extend, modify, or limit the statute's express terms or its reasonable or obvious implications because to do so would be an abrogation of legislative power. Moreover, all parts of a statute must be read together in order to achieve a consistent whole. Effect must be given to every clause of the statute and meaning given to all of its parts. Yeah, a bunch of jumbo. Here, the trial court erred by not considering the entirety of Section 39203, subsection 1A, and its application to the facts of this case beyond J. Hatch's immunity from claims premised on or immediately resulting from the reports of suspected child abuse. And nothing in the record suggests that J. Hatch's participation in implementing the dependency court orders as it was required to do was not done in good faith. Although the process was unfortunately slow and painful for the Dowderies, nothing reveals that the investigation was not instituted and conducted in good faith after a legitimate report of abuse. As such, the department, as an institution participating in good faith in acts authorized or required by subsection 415, 502, 415, 514, was immune from civil liability, which might otherwise result by reason of its action. Pope versus State. The state argues correctly that Pope could have and should have done more, but the legislature did not condition immunity on doing more than seeking medical assistance in good faith. The legislature could have imposed more conditions. The statutory scheme at issue is intended to protect those who might be overzealous in protecting children from potential abuse. See Floyd v. Department of Children and Families. All right, let's see. We'll scroll down here past this case law stuff. There are complexities created by the interplay of Chapter 39 with the claims raised in this case. We are aided in interpreting and applying Chapter 39 by the amicus curiae briefs filed by the American Academy of Pediatrics, the Children's Hospital Association, and the Florida Hospital Association. The Florida Hospital Association articulated its concerns with the trial court's ruling in this case. Trial court found as a matter of law that J. Hatch had a reasonable basis for suspecting that their patient was the subject of child abuse, that J. Hatch acted in good faith in reporting that suspicion, and that J. Hatch could not be held liable for any cause of action directly arising from sheltering the child pursuant to a court order. Unfortunately, these findings were rendered meaningless at the trial itself when the court permitted the Kowalskis to attack J. Hatch's basis for suspecting abuse. Its motives for reporting that suspicion and present evidence to the jury of the psychological impact of the court-ordered sheltering period. The actions of J. Hatch with respect to their good faith, mandatory reporting were repeatedly called into question and leveraged by the Kowalskis in their effort to secure a finding of civil liability and an award for damages. That don't sound too good. The court found that Section 39203, subsection 1A, immunity flows for any civil liability that may result by reason of the child abuse report, and that without question, an investigation, shelter, removal of custody, and prohibiting visitation all are outcomes that logically could occur from a report to the abuse hotline. Footnote 11. Whether the trial court's interpretation is correct in this respect has not been raised by the parties to this appeal. We note, however, that the plain language of the statute provides immunity from civil liability resulting from good faith abuse reports. Whether civil liability results from, or as the trial court found, flows from, the abuse reports or from other acts authorized or required by Chapter 39 is not a distinction we must draw in this case because J. Hatch was required to comply with dependency court orders as a matter of its good faith participation in the Chapter 39 proceedings, regardless of whether its compliance with court orders flowed from the abuse reports. All right, where were we? That was footnote 11. Okay, the trial court implicitly recognized that dependency court orders, that is, those sheltering a child and restricting or prohibiting visitation, may result from the reporting and investigation of abuse. Yet the trial court failed to give effect to its interpretation by permitting the jury to hear significant and inflammatory testimony concerning the restrictions put in place by the dependency court and the impacts of those restrictions on the Kowalskis. For example, Mr. Kowalski testified that Mrs. Kowalski lost consciousness and fell to the floor upon learning that she was not going to be able to see Maya, and that during the time that she was unable to see Maya, Mrs. Kowalski deteriorated. She was losing hope. He repeatedly testified to the profound impacts of the dependency court orders on Mrs. Kowalski. Maya also testified to the impacts of the dependency court orders on her, from anger in not being able to speak with her or see her mother to feelings of isolation. Maya testified that she was suspicious about the comments made to her and the restrictions placed on her. No one ever directly told her what was going on, and she had to figure out for herself that she was being stripped from her family. She testified that JHatch provided her with a My Care journal, and that in it she listed names of JHatch doctors and nurses with notations and drawings. I was trying to get out of the hospital, and I'm 10, so I'm thinking if they think I like you, then I'll get out. Wow, that's terrible. That is terrible. Footnote 12. The closing arguments were also inflammatory. Counsel for the Kowalskis argued that JHatch took Mrs. Kowalski out of the game by changing its diagnosis and treating the Kowalskis like criminals. Counsel then went through JHatch's defenses because if we get rid of the defenses, then all that is left is the Kowalskis' case. Counsel for the Kowalskis argued that something happened between Mrs. Kowalski and JHatch that ticked JHatch off, causing JHatch to call the department, and that JHatch was not going to let this brusque lady with an Eastern European accent come in and tell them how to do their job. They argued that JHatch calling the department hotline was retaliatory against Mrs. Kowalski and that she committed suicide because she knew that if she did not take drastic action, Maya would end up in some kind of foster care or die. I believe that Beata Kowalski, her mother, did believe that. I 100% believe that. And that's after watching the entire trial. And here's another thought on that is how doesn't that go to her state of mind? You know, all these thoughts about how, you know, they talk about nobody told her what was going on and that she had to figure it out for herself, that she was being stripped from her family. She testified that JHatch provided her with a My Care journal and that in it she listed names of JHatch doctors and nurses with notations and drawings. I was trying to get out of the hospital and I'm 10, so I'm thinking if they think I like you, then I'll get out. I mean, what more do you need to know? I mean, come on. That's obviously goes to her state of mind, what she was thinking and why she was thinking it. So I don't think that it's really anything to do with inflammatory to the jury, you know, or limiting their or get rid of their defenses. Closing arguments is just that, closing arguments. It's not evidence. They're not supposed to base it on closing arguments. They're supposed to base the verdict off of the evidence. So closing arguments have nothing to do with nothing. All right, let's go back up to the top here. Number 12. All right, the trial court erred by not giving effect to that portion of the statute to which it assigned meaning, and it further erred by not giving meaning to all words within the statute. Courts must give significance and effect to every word and phrase in a statute. Section 39203, subsection 1A provides immunity from civil liability, which might otherwise result by reason of both reporting in good faith any instances of child abuse and participating in good faith in any act authorized or required by Chapter 39. 91 of Maya's 97 days in JHatch were the result of dependency court orders wherein the department had been given placement and care responsibility of Maya while she remained under protective supervision. JHatch urges that the trial court's errors in interpreting and applying Section 39203, subsection 1A, immunity should result in a new trial for all claims. Footnote 13. We note that JHatch has not argued that evidence of good faith participation in actions authorized or required by Chapter 39 is not admissible because such actions cannot form the basis for liability. The FHA, Florida Hospital Association, however, contends that if a party is immune from any civil liability that might otherwise result by reason of certain conduct, then evidence of such conduct should not be offered as part of an effort to support a finding of any form of civil liability, and that offering such evidence creates an obvious and significant danger of unfair prejudice, confusion of issues, and misleading the jury. Florida Statute 2023, Section 90, subsection 403. Okay, footnote 14. Oh, we already read that, right? Oh, no, we didn't read footnote 14 yet. We agree that the trial court's rulings on Section 39203, subsection 1A, immunity permeated the entire trial. A new trial is required on all counts not otherwise disposed of by this opinion. See false imprisonment, October 7th through 13th, 2016. The trial court denied J. Hatch's motion for directed verdict as to the false imprisonment claim for J. Hatch's actions between October 7th and October 13th, 2016. This was error. The essential elements of a cause of action for false imprisonment include 1. The unlawful detention and deprivation of liberty of a person. 2. Against that person's will. 3. Without legal authority or color of authority. And 4. Which is unreasonable and unwarranted under the circumstances. So they had it under color of authority and legal authority because the dependency court ordered it. So the dependency court ordered it, so they don't have a choice but to follow the court order. It's just like if you or I were to get a court order to show up to court tomorrow, we have to go to court. Or if we get a summons to go to court for jury trial, we have to go to court. It's a court order. You must obey a court order. So, I mean, it's the same concept. So I guess it makes sense to me then. All right, footnote 14. Although J. Hatch sought summary judgment for this false imprisonment claim, as well as the other false imprisonment claims on the basis of Section 39203 immunity, J. Hatch does not challenge the court's denial of its motion for summary judgment. The only challenge it raises on appeal as the October 18th through October 20th and January 6th false imprisonment claims concerns punitive damages. All elements must be proven for a plaintiff to recover on a false imprisonment claim. The October 7th through October 13th allegations stem from J. Hatch's refusal to release Maya from the ER in PICU. J. Hatch argues both that it had legal authority and that there was no evidence that keeping Maya in its care was unreasonable and unwarranted under the circumstances, whether because of Maya's pain levels and overall health at the time or because of the suspected child abuse. We need only consider whether the hospital was without legal authority or color of authority, a question of law, to resolve this issue. Let's see. Whether the Florida Public Service Commission has the authority to act as a question of law, which is subject to de novo review. J. Hatch's legal authority or color of authority stems from Section 39395. Any person in charge of a hospital or similar institution or any physician or licensed healthcare professional treating a child may detain that child without the consent of the parents, caregiver, or legal custodian, whether or not additional medical treatment is required. If the circumstances are such, or if the condition of the child is such that returning the child to the care or custody of the parents, caregiver, or legal custodian presents an imminent danger to the child's life or physical or mental health. That's scary. If you didn't just follow me along on that and actually listen, that's scary. Basically, if you go to the hospital and they think that it's safer for your child to be at the hospital than it is for them to go home, they can make that decision that your child stays there without a court order. That your child will stay there until they feel he's fit or she's fit to go home with you. And it's not an imminent danger to the child. That's scary. How free are we really in America? I mean, this is just absolutely scary. Okay, emphasis added. We are mindful that Section 39-95 also requires that any such person detaining a child shall immediately notify the department and that the department shall immediately begin a child protective investigation in accordance with the provision of this chapter. Beyond the initial detention and reporting to the department, the legislature has placed no burden on the person detaining the child. Instead, it has placed the burden on the department. If the department determines, according to the criteria set forth in this chapter, that the child should be detained longer than 24 hours, it shall petition the court through the attorney representing the Department of Children and Families as quickly as possible and not to exceed 24 hours for an order authorizing such custody in the same manner as if the child were placed in a shelter. Certainly, Section 39-395 provides color of authority for J. Hatch's detention of Maya in the ER and PICU during the period between the first and second reports to the department. And following the second report on October 9, 2016, the department instituted its investigation. Moreover, J. Hatch's actions were authorized or required by Chapter 39, and there is no evidence that its participation was not in good faith, particularly where the trial court concluded as a matter of law that J. Hatch had reasonable cause to suspect child abuse. As such, J. Hatch is immune from liability resulting from its detention of Maya between October 7th and October 13th, 2016. Accordingly, J. Hatch's motion for directed verdict on the claim of false imprisonment for the period of October 7th through October 13th, 2016 should have been granted. Footnote 15. J. Hatch's issue concerning the corresponding motion for directed verdict on punitive damages is therefore rendered moot. So it's rendered moot. So, not relevant. Intentional infliction of emotional distress, Beata Kowalski. Two claims of intentional infliction of emotional distress specific to Beata Kowalski were resolved by the jury in favor of the Kowalskis after the trial court denied J. Hatch's motions for directed verdict. J. Hatch contends that its motions for directed verdict should have been granted because the Kowalskis failed to present evidence of conduct directed at Mrs. Kowalski, and the Kowalskis' evidence was insufficient as a matter of law. We agree. Ooh. Footnote 16. We therefore decline to address J. Hatch's argument that Florida does not recognize IIED suicide. All right, that was footnote 16, right? Yeah, okay. To support a claim for IIED, a plaintiff must prove, 1, the wrongdoer's conduct was intentional or reckless, that is, he intended his behavior when he knew or should have known that emotional distress would likely result. The conduct was outrageous, that is, as to go beyond all bounds of decency and to be regarded as odious and utterly intolerable in a civilized community. 3, the conduct caused emotional distress, and 4, the emotional distress was severe. The trial court must make the initial determination on a motion for directed verdict that the evidence presented meets that high standard. Okay, and because the outrageousness test is objective, testimony as to the plaintiff's beliefs on whether the defendant intended to cause emotional distress is of no moment. Likewise, the subjective response of the person who is the target of the actor's conduct does not control the question of whether the tort of intentional infliction of emotional distress occurred. As relevant to the estate's IIED claims, intentional infliction of emotional distress is IIED. In order to state a claim for IIED based on one's own emotional distress, a plaintiff must present when the alleged extreme and outrageous conduct conducted is directed toward a third party. Okay. The Kowalskis presented no evidence that Mrs. Kowalski was the target of any of the conduct alleged to be outrageous. Rather, the heart of the Kowalskis' claim, repeated in various ways throughout multiple bench conferences and asserted before the jury, was that the separation of mother from child with knowledge by both and without ability to combat it was outrageous. The Kowalskis argued, a plan that is told to the mother that we're going to take away your child and there's nothing you can do about it. The real outrageousness is the systematic nature of the actions against Mrs. Kowalski through this. And every contact that she had and everything she learned reinforced that there was a plan to take her daughter away. And that is outrageous in our society. The Kowalskis contended that there were concerted efforts to raise the pressure on Mrs. Kowalski. If this doesn't get her, let's suggest that Mr. Kowalski get a divorce. And if this doesn't get her, let's tell Maya that I'm going to be her mother. The Kowalskis acknowledged that these statements were not made directly to Mrs. Kowalski because she wasn't allowed in the hospital, but were funneled to her through a proxy, which was her child or her husband. that Mr. Kowalski or Maya relayed what they had seen or experienced is not evidence that J. Hatch's actions were directed to Mrs. Kowalski. And there was no evidence that Mrs. Kowalski was somehow the target of statements made to either Maya or Mr. Kowalski. Moreover, the trial court recognized that the allegations in the operative complaint were insufficient when it granted J. Hatch's pretrial motion to dismiss the IIED claim as to Mr. Kowalski, with the exception of actions immune under Section 39203, subsection 1A, and the assertion that Mrs. Kowalski suffered from Munchausen syndrome by proxy. There is little difference between the allegations the trial court found legally insufficient as to Mr. Kowalski's claim and evidence presented as to the estate's claims. The Kowalski's evidence was legally insufficient to survive directed verdict. The motions for directed verdicts on the IIED claims specific to Mrs. Kowalski should have been granted. E. Intentional infliction of emotional distress. Maya Kowalski. In denying J. Hatch's motion for directed verdict specific to Maya's IIED claim, the trial court considered evidence for which J. Hatch should have been immune from liability and evidence of other pleaded torts. This was error. We reiterate that the actions for which J. Hatch should have been immune pursuant to Section 39203, subsection 1A, cannot be used to establish liability. The department placed Maya with J. Hatch. J. Hatch's participation in the Chapter 39 proceedings, as well as its initial reports of suspected child abuse to the department, pervaded the Kowalskis' evidence of intentional infliction of emotional distress against Maya. The trial court was required to consider which of J. Hatch's actions should have been immune from liability and which actions could support the independently pleaded tort of IIED. Medical professionals' disagreements about a complex medical case and perhaps overzealous implementation of dependency court orders are not acts that are intolerable in a civilized community. I disagree. Good faith actions to protect children are neither utterly intolerable in a civilized community nor beyond all possible bounds of decency. Indeed, Section 39203, subsection 1A, immunity, protects those who might be overzealous in protecting children from potential abuse. See Floyd 855. To the extent J. Hatch took actions within its legal rights under Chapter 39 or otherwise, it cannot be liable for IIED. Additionally, a privilege exists as a matter of law to engage in reckless or even outrageous conduct if there is sufficient evidence that shows the defendant did more than assert legal rights in a legally permissible way. Additionally, IIED conduct must not be volatile of any other recognized tort. That is, the facts upon which it is based must be independent of any other alleged tort. Because the actions of the chargeable defendants here can be deemed to fit within the false imprisonment category, those actions will not support a claim of intentional infliction of emotional distress. Obviously, if the sole basis of a complaint for emotional distress is a privileged defamatory statement, then no separate cause of action exists. A plaintiff cannot transform a defamation action into a claim for intentional infliction of emotional distress simply by characterizing the alleged defamatory statements as outrageous. Citation omitted. Where the conduct alleged to be outrageous is itself a pleaded tort, a claim of IIED cannot lie. Here, the Kowalskis relied upon evidence of other pleaded torts in order to establish the IIED claim. The law is clear, however, that the evidence supporting Maya's 3 false imprisonment claims, as well as her battery claims and medical negligence claim, cannot also be used to meet the legal threshold for her IIED claim. Footnote 17. Further, evidence supporting the negligent hiring and supervision claim cannot be used. That claim was resolved in favor of J. Hatch, and while the Kowalskis argued that the evidence taken as a whole indicates that there was a desire and plan on the part of Mrs. Beatty to separate Maya from Mrs. Kowalski, and that there was a plan by the hospital to force Mrs. Kowalski and Maya and Mr. Kowalski to change their story. To the extent that such evidence is not subject to Section 39203 immunity, there is no evidence of any such concerted effort. Concluding that plaintiff's testimony as to her beliefs on whether defendant intended to hurt her was of no moment. The subjective response of the person who is the target of the actor's conduct is not to control the question of whether the tort of IIAD occurred. Moreover, the trial court granted summary judgment in favor of J. Hatch on the Kowalski's conspiracy claim pretrial. F. Medical negligence. Apparent agency J. Hatch contends that the trial court erred in denying its motions for directed verdict on the narrow issue of apparent agency as it relates to Dr. Smith, and that Chapter 39 otherwise immunizes Dr. Smith's actions such that J. Hatch cannot be held liable for those actions. We agree. An apparent agency exists only if all three of the following elements are presented: a representation by the purported principal, a reliance on the representation by a third party, and C, a change in position by the third party in reliance on the representation. Mr. Kowalski testified that he was unaware that Dr. Smith was not a J. Hatch doctor at the time he first met her, but he could not specify the date. He testified that she was wearing a white lab coat when she came into Maya's room and started asking questions. Maya testified that she was unaware of who Dr. Smith was or in what capacity she questioned Maya's father. An email dated October 12, 2016 from Mrs. Kowalski's email address was entered into evidence. In the email, Mrs. Kowalski reported that on October 11, 2016, she and Dr. Sally Smith, who was sent by the department to investigate the possible child abuse neglect, had a second visit at which Mrs. Kowalski described Maya's illness and the doctors involved in Maya's care. Thus, no later than October 11, 2016, Mrs. Kowalski was aware that Dr. Smith was acting in her capacity as a child protective team physician. And certainly, by the October 14th shelter hearing, Mr. Kowalski was also aware. The Kowalskis presented no evidence that they materially changed their position prior to October 11th or October 14th on the basis of Dr. Smith being an apparent agent of J. Hatch. Rather, the Kowalskis acknowledged that they were unaware that J. Hatch had given Dr. Smith full access to Maya's medical records at the time such access was provided. The apparent agency theory should have been rejected as a matter of law by the trial court, and a directed verdict as to that specific claim should have been granted. Nonetheless, even were Dr. Smith an apparent agent of the hospital because Dr. Smith was the CPT medical director, she was authorized by Chapter 39 to take the actions that she took. Her actions would not subject J. Hatch to liability unless J. Hatch was not participating in good faith in acts authorized by Chapter 39. It was the Kowalskis' burden to prove either that J. Hatch was not participating in good faith in authorized or required acts, or that Dr. Smith was not acting in her capacity as the CPT medical director. In admitting evidence of Dr. Smith's actions without proper consideration of the statutory immunity, the trial court relieved the Kowalskis of their burden. G. Punitive damages. J. Hatch contends that the trial court erred in denying its motions for directed verdict on the issue of punitive damages as to the false imprisonment and battery claims. Footnote 18. Although our reversal of the judgment as to the October 17th through October 13th false imprisonment claim moots the issue specific to that claim, we would have otherwise concluded that directed verdict was warranted as to punitive damages because J. Hatch's actions during that period do not meet the definition of either intentional misconduct or gross negligence. In all civil actions, the plaintiff must establish at trial by clear and convincing evidence its entitlement to an award of punitive damages. And a defendant may be held liable for punitive damages only if the trier of fact, based on clear and convincing evidence, finds that the defendant was personally guilty of intentional misconduct or gross negligence. Clear and convincing evidence, an intermediate burden of proof, requires that the evidence must be found to be credible. The facts to which the witnesses testify must be distinctly remembered. The testimony must be precise and explicit, and the witnesses must be lacking in confusion as to the facts in the issue. The evidence must be of such weight that it produces in the mind of the trier of fact a firm belief or conviction without hesitancy as to the truth of the allegations sought to be established. In the case of an employer, principal, corporation, or other legal entity, punitive damages may be imposed for the conduct of an employee or agent only if the conduct of the employee or agent constitutes intentional misconduct or gross negligence, and the employer, principal, corporation, or other legal entity, actively and knowingly participated in such conduct. B, the officers, directors, and managers of the employer's principal, corporation, or other legal entity knowingly condoned, ratified, or consented to such conduct. Or C, the employer, principal, corporation, or other legal entity engaged in conduct that constituted gross negligence and that contributed to the loss, damages, or injury suffered by that claimant. Let's see. Section 768.72, subsection 3. Intentional misconduct is defined as a defendant having actual knowledge of the wrongfulness of the conduct and the high probability that injury or damage to the claimant would result. And despite that knowledge, intentionally pursuing that course of conduct resulting in injury or damage. Gross negligence is defined as conduct so reckless or wanting in care that it constituted a conscious disregard or indifference to the life, safety, or rights of persons exposed to such conduct. As to the January 6 battery and false imprisonment claims, Ms. Beatty testified that she was told to take photographs of Maya before Maya could leave the hospital for the dependency court hearing. The Kowalskis presented evidence that a risk management analyst within the risk management department of JHatch directed the actions on January 6th. Evidence established that it was JHatch's policy that the risk management department reports to senior counsel and then senior counsel reports to the president of JHatch. There was no clear and convincing evidence that JHatch actively and knowingly participated in or engaged in intentional misconduct or gross negligence. A managing agent is an individual like a president or primary owner who holds a position with the corporation which might result in his acts being deemed the acts of the corporation. Go down here. Likewise, there was no clear and convincing evidence that the actions in question in this case were relayed to senior counsel or to the CEO, much less that anyone ratified or condoned the actions other than the risk management analyst. Footnote 19. There's also evidence that JHatch's risk management committee does not function in real-time decision and meets only quarterly. Before one may infer that a principal ratified on an unauthorized act of his agent, the evidence must demonstrate that the principal was fully informed beyond having simple constructive knowledge and that he approved of the act. And there was no evidence that a risk management analysis satisfies the statutory requirement of officer, director, or manager of employees. Finally, to the extent that the Kowalskis argued ratification after the fact, actions taken after the happening of a tortious act are not admissible on the issue of punitive damages, nor can those subsequent actions form the basis for bringing such a damage claim. In the absence of clear and convincing evidence, the issue of punitive damages should not have gone to the jury. Damn. That's terrible. Shouldn't have gone to the jury. So basically, it sounds to me like they are immune by Chapter 39 for everything they did. Everything they did, they were immune from day one, even before the court order by the dependency court. When they held her there, they had the right to do that. They had the legal right to do that. This is sick. This is scary that these places can get away with this. And then they've just got all this money that they can just throw at it. Just throw it. Millions and millions and millions of dollars that they've spent on this. I mean, granted, I get it. It's a lot cheaper than spending $261 million to pay the punitive damages. But I think they were only paying out $50 million. The insurance and everybody else was paying it out for them. So they were only paying $50 million out of pocket, I think. So, but this is what causes change. You're not going to have change in the hospital system, in the medical care system, unless stuff like this happens. Now, I'm here to tell you that this ain't the first family this has happened to. There's quite a few other families this has happened to. That Greg Anderson and Nick Whitney, Maya Kowalski's two main attorneys during the trial, have spoke with him and spoke on the internet about these other people. I forget the other family, but there's another family that's also outspoken about it, that lost their child and all, through dependency court and all this crazy stuff. All based on Dr. Sally Smith's assumption and accusations, because she's privatized. And the more cases she gets, the more money she makes. If she doesn't get no cases this week, she don't get that extra money or bonus or whatever she gets for extra cases, because I'm sure she gets a weekly salary for not doing anything, whether she does anything or not. So it's just absolutely insane how much control we don't have over our children. We don't have control over our children like we think we do. It's scary to go to the doctors. It's scary to go to the hospital with young children, minor children anymore. All it takes is one phone call. One phone call. It's over. Here they are knocking on your door. Or before you know it, they're not even knocking on your door. They're at the hospital. They're at the doctor's office. In the room. You didn't even get a chance to get away. This is what they do. DCF, CPS, all that crap, DCS, whatever you want to call them, they're terrible. They're awful. They're terrible human beings. Anybody that works in that sector, I'm sorry, but if you work in CPS, you can't be a good person. I mean, you just can't be. If you do anything where you take children from families. I get it. There's children that need to be taken. I understand that. But I'm talking and referring specifically to the ones that fabricate. I mean, it says right in the papers. She came in to the hospital room in a white lab coat. A J-Hatch white lab coat. She don't even work for J-Hatch. She's just an agent of J-Hatch. She works for DCF. But she came in the room and started asking a bunch of questions. Just randomly came in. They had no idea who she was. Till later on. But she came in and demanded a bunch of questions. I believe that they were in the middle of changing Maya. She had a dirty, soiled linen. And they were changing her. And Dr. Sally Smith still come in the room asking a bunch of questions while Dad's changing her out. I mean, how sick. This is what they did to this little girl. It's just absolutely sickening. It's just sickening. All right, enough of me talking. Let me get back to it. All right, as to the October 18th through October 20th false imprisonment claim, there was no evidence that the physicians involved in moving Maya to the EEG room had actual knowledge of the wrongfulness of the conduct, or that moving Maya into the room with video monitoring was reckless or wanting in care. Really? You didn't know that it was reckless to put the little girl in a surveillance room so that you could put the commode just out of reach so that she could have to get up and walk to it because you knew she could walk? I mean, come on. This is just appalling. And this is our courts agreeing with this. Okay? I'm not saying that I agree with everything they're saying. And I certainly don't disagree with everything they're saying. Some of it I do certainly agree with. But I mean, come on. When is enough enough? Further, like the claims for the January 6th false imprisonment and battery, there was no evidence presented that J-Hatch participated in the actions or that the officers, directors, or managers of J-Hatch condoned or ratified the conduct. Let's see. That's about the case law. Okay, concluding that there was insufficient record evidence to establish that treating physician knew that there was a high probability that additional injury or damage would result to patient, or that treating physician or president of hospital condoned or ratified actions taken. The trial court erred in submitting the punitive damages claim to the jury. H. Fraudulent billing. The trial court denied J-Hatch's motions for directed verdict on Mr. Kowalski's claims that J-Hatch fraudulently billed the Kowalski's health insurance carrier by using a billing code for CRPS. To survive directed verdict, Mr. Kowalski had to establish that J. Hatch made a false statement concerning a material fact in the bills to Mr. Kowalski and his insurance company. That J. Hatch knew the statement was false when it made it. That J. Hatch intended that Mr. Kowalski or his insurer would rely upon the false statement, and that Mr. Kowalski or his insurer was injured as a result of that reliance. Therefore, there are four elements of fraudulent misrepresentation. 1. A false statement concerning a material fact. 2. The representer's knowledge that the representation is false. 3. An intention that the representation induce another to act on it. And 4. Consequent injury by the party acting in reliance on the representation. Generally speaking, to satisfy the element of an injury, the claimant must establish that he or she has sustained pecuniary damage or injury by which he or she has been placed in a worse position than he or she would have been absent the fraud. J. Hatch contends that the trial court erred in denying its motion for directed verdict, where Mr. Kowalski presented no evidence that J. Hatch made a false statement of material fact in billing Mr. Kowalski's insurance carrier under a code for CRPS, and he presented no evidence of damages. We agree. There is no dispute that Maya was admitted to J. Hatch having already been diagnosed with CRPS by another physician. The dispute concerns J. Hatch's billing of the Kowalski's insurer, where, according to Mr. Kowalski, the hospital did not believe that Maya had CRPS and did not treat Maya for CRPS. Evidence of J. Hatch's billing was introduced, as was evidence of payments by the insurer. However, Mr. Kowalski presented no evidence that J. Hatch's bills included false statements. That is, Mr. Kowalski presented no evidence that J. Hatch billed for services or treatments it did not perform, or that it billed under a diagnosis that Maya did not have. J. Hatch's bills included as many as 12 diagnosis codes, and Mr. Kowalski was unable to testify what percentage of the insurer reimbursement was for CRPS versus the other codes, including nutrition, endoscopy, and child neglect abandonment. Further, Mr. Kowalski presented no evidence that he suffered pecuniary injury for the alleged fraudulent billing. He presented no evidence that he was billed for treatment, whether as deductible, copay, or balance payment, that was associated with a CRPS diagnosis. In fact, Mr. Kowalski concedes in this appeal that no damages in the form of increased copays, premiums, or deductibles were proven at trial. Moreover, in closing argument, counsel for Kowalski suggested that the jurors award $1 in nominal damages for this claim unless they found evidence of an increase in insurance costs or copays. Post-verdict, Mr. Kowalski agreed to remit the jury award to $2 because Mr. Kowalski requested damages only for deductibles or copays incurred, and difficulty of finding insurance in the future in the operative complaint, and such damages were not proven. Where the claimant is unable to prove that he or she was injured by the alleged misrepresentation, the trial court must grant a directed verdict on the claim. The trial court erred in denying J. Hatch's motion for directed verdict on this claim. I. New trial. The complexities in this case are only more complicated by the existence of immunity pursuant to Section 39-203, subsection 1A. J. Hatch contends, as it did below, that the trial court's error in interpreting Section 39-203 pervades not only the court's evidentiary rulings, but the trial itself, such that a new trial on all remaining counts is necessary. Footnote 21. We do not address whether those claims survive on remand under a correct application of Section 39-203, immunity or otherwise. We would exceed our function were we to give an opinion on the merits of any of the claims for which a new trial is required. It is incumbent upon the parties to present the case anew, and for the trial... and for the trial court to rule on the evidence and issues arising therefrom and presented to it. We decline to address events which may or may not occur at the retrial of this case. The new trial which our action envisions should be neither prejudiced nor watered down by obiter dicta. Footnote 20. Despite the concession that no Pecuniary damages for fraudulent billing were proven at trial. Counsel for the Kowalskis suggest that the trial court correctly denied the motion for directed verdict because the jury was entitled to consider Mr. Kowalski's loss of Mrs. Kowalski as billing fraud damages, and Mr. Kowalski's loss of Mrs. Kowalski would have reasonably supported a verdict of $5 million for billing fraud. No authority is cited for this argument, and we have found no basis in the law to support it. This might sink Anderson Glenn, because they spent a lot of money, on this trial. Experts, that kind of stuff. Like a lot of money. And they're going to have to do this again? Pay all these people again? They might not go to trial again. They might not have the money to do it. Okay, so we'll go back down here. Okay, as discussed herein, we agree. Moreover, the totality of all errors and improprieties, including those not discussed herein, were pervasive enough to raise doubts as to the overall fairness of the trial court proceedings. Conclusion: the final judgment in favor of the Kowalskis is reversed. On remand, only the IID claim brought on behalf of Maya and the remaining false imprisonment, battery, and medical negligence claims may be retried. Okay, so the final judgment in favor of the Kowalskis is reversed. On remand, only the IIED claim brought on behalf of Maya and the remaining false imprisonment, battery, and medical negligence claims may be retried. So four counts, 4 charges, claims. Reversed and remanded with instructions. LaRose J. concurs. Smith J. concurs, specially. Smith Judge. Specially concurring. I concur in the majority opinion, but write separately to elaborate on the discrete issue of whether J. Hatch was entitled to judgment as a matter of law on the threshold issue of outrageousness on Maya's claim for intentional infliction of emotional distress. Maya, age 10, presented to the hospital with a pain score of 10 out of 10. Ms. Beatty, a licensed clinical social worker employed by the hospital, was in charge of overseeing and making sure that J. Hatch followed the dependency court orders, including the monitoring of hospital visits and phone conversations with Maya's friends and family, including her mother. Ms. Beatty spent considerable time with Maya, overseeing her care, including her physical therapy, and taking Maya to the hospital chapel. She testified that Maya was in her wheelchair 95% of the time that she saw her. She also testified that Maya told her that she was furious, angry, and in pain. She told Ms. Beatty she can't talk to or trust anyone. Ms. Beatty was privy to emails that highlighted the hospital's concerns that Maya was self-mutilating. Maya maintained throughout her stay in the hospital that she was in debilitating pain and testified that she was worse off at the time of her discharge than when she was presented to the hospital. Maya also complained that her CRPS lesions returned while she was in the hospital and were causing her pain. This is all to say that Maya was a patient, in pain, in a vulnerable state, not only because she was a patient dealing with debilitating pain, but also because of her tender age of 10. From this evidence, a case was made by Maya that Miss Beatty took advantage of Maya's circumstances in her vulnerable state. She lied to Maya that Maya's mother was getting mental health treatment, telling Maya that she may have to go into medical foster care and that Miss Beatty could be her mother while she was in foster care. She further lied to Maya and used things that Maya enjoyed to encourage Maya to do better at physical therapy. But instead of rewarding her, she would stomp and leave the room, saying that Maya did not do well enough. Maya also established at trial through her own testimony that the nurses spoke loud enough for Maya to overhear that they believed that her mom was causing her symptoms. Maya testified that the nurses berated her and accused her of faking her ailments. She stated that a bedside toilet was placed far from her bed so that she could not reach it without walking, which she could not do. Maya would call for help to go to the bathroom, but no one would come in and take her, so she was forced to wet or soil herself in bed or otherwise fall and injure herself. Maya testified that the statements and actions of the nurses and Ms. Beatty were done to break her down and prove and or force her to admit that she was faking her symptoms. Maya pleaded in her Eighth Amended complaint an IIED claim, alleging these behaviors caused severe emotional distress and bodily harm. The complaint specifically referenced Maya's vulnerability as a minor while she was a patient at J. Hatch, alleging the defendant's offenses are aggravated by the fact that Maya was a minor during the time of this outrageous conduct. The tort of IIED was first recognized by the Florida Supreme Court in Metropolitan Life Insurance versus McCarson. In Metropolitan, the court set out the 4-part test as defined by Section 46, Restatement of Torts. 1. Deliberate or reckless infliction of mental suffering. 2. Outrageous conduct. 3. The conduct caused the emotional distress. And 4. The distress was severe. This appeal concerns prong 2 as discussed in the initial brief and majority opinion, and so I only address this prong. Florida courts have long recognized severe emotional distress claims by vulnerable individuals under Section 46, Restatement Second of Torts. 1965. Prior to Metropolitan, the 3rd District recognized that statements to a child of tender years can cause severe emotional distress under Section 46. See Corbin versus Berlin. In Corbin, the court reversed the dismissal of a severe emotional distress claim brought under Section 46 of the Restatement of the Law of Torts, 1948 supplement, by a guardian on behalf of a 6-year-old child against the defendant. The defendant was alleged to have approached the child and said, Do you know that your mother took a man away from his wife? Do you know God is going to punish them? Do you know that a man is sleeping in your mother's room? God will punish them. The question posed by the court was whether that was said to the child was intended or reasonably calculated to cause the child severe emotional distress. The court answered that the question in the affirmative, holding the alleged statement in the manner and circumstances under which they were communicated. To the child leave little room to doubt they were made with a purpose and intent to shame her, and to shock the sensibilities of this child of tender years. Relating, as they did to the child's mother, the content and import of the statements were such that it cannot be said as a matter of law that this alleged deliberately harmful act was not one calculated to cause severe emotional distress to a person of ordinary sensibilities. Following Metropolitan, the 5th District recognized an IAD claim by a vulnerable patient against a healthcare provider. In McAlpin, the complaint alleged that the adult patient went to the hospital for an x-ray for her swallowing condition that caused speech difficulty and panic during attacks. Upon entering the x-ray area, the patient was verbally assaulted by a hospital physician who claimed that because the patient owed the physician's friend money, the patient would not pay the hospital bill. The physician threatened to have the patient removed from the hospital. The complaint further alleged that the actions of the physician were designed and did take advantage of the vulnerability of the patient, submitting as she was to diagnostic tests while in fear for her health and depending for comfort and solace upon the caring and supporting atmosphere to be generated by the hospital. The trial court in McAlpin granted the physician's motion to dismiss with prejudice, finding that the physician's demand for the patient to pay the friend's bill, while, albeit not a favored method, was not sufficiently outrageous to arise to the level of an IIED claim. The 5th District disagreed, holding that the allegations of the complaint, if proved, support the patient's argument that a jury, as the trier of fact, could find that the physician's conduct was reckless and utterly outrageous in a civilized community. The physician acted in deliberate disregard of the high degree of probability and emotional distress would follow. In so holding, the district court reversed the dismissal of the IIED claim, recognizing the special relationship between a physician and a patient and that the actions of the physician met the threshold test of extreme conduct which would cause an average member of the community to exclaim outrageous. This court has indeed held that the extreme and outrageous character of the conduct may arise from the actor's knowledge that the other is peculiarly susceptible to emotional distress by reason of some physical or mental condition or peculiarity. Instead, this court found instructive comment F to Section 46 of the Restatement of Torts because it explains how knowledge of a person's particular susceptibility to emotional distress is relevant to determining whether the conduct is sufficiently extreme and outrageous to constitute intentional infliction of emotional distress. Affirming judgment for plaintiff following a bench trial where a physician cursed and screamed at a patient who was known by the physician to be susceptible to emotional distress. Comment F reads, the extreme and outrageous character of the conduct may arise from the actor's knowledge that the other is peculiarly susceptible to emotional distress by reason of some physical or mental condition of peculiarity. The conduct may become heartless, flagrant, and outrageous when the actor proceeds in the face of such knowledge, where it would not be so if he did not know. It must be emphasized again, however, that major outrage is essential to the tort, and the mere fact that the actor knows that the other will regard the conduct as insulting or will have his feelings hurt is not enough. Okay, more case law. We must acknowledge that the unequal position of the parties in a relationship where one asserts and has the power to affect the interest of the other may also supply the heightened degree of outrageousness required for a claim of IIED. IIED claims exist where one is susceptible to emotional distress or due to the unequal positions of the parties, and this was raised by the Kowalskis in the 8th amended complaint. Specifically, the complaint asserted that Maya, age 10, was sheltered and placed in the care and custody of J. Hatch, that J. Hatch was charged with looking out for the best interests of Maya while in their care, and that Maya was isolated from her family, friends, schoolmates, and priest. I believe the allegations pleaded in the 8th Amendment complaint and as more fully developed at trial support Maya's theory of recovery for IIED under both comment F and I of Section 46. Restatement of torts. What is odious and utterly intolerable in a civilized community about the conduct here is that a licensed social worker in charge of the care of her patient should not lie and tell her patient, especially a patient of such a young age, that her mother, who has cared for her, is getting mental health treatment and will not be able to take care for her in the near future. Instead, consoling the child that she will be fine in foster care where that social worker can be her mother. Further, the berating by the nurses that Maya was faking her symptoms is equally odious and utterly intolerable in a civilized community, especially given Maya's physical condition and their knowing that Maya believed herself to be suffering from CRPS. Just as the patient at the McAlpin went to the physician for an x-ray for her medical problems and instead received verbal abuse, Maya too went to the hospital for debilitating pain and treatment only to be broken down, mentally abused, and berated by Ms. Beatty and the hospital nurses who were in a position to facilitate her care and treatment. Based upon Maya's mental and physical condition, Ms. Beatty and the nurses acted in deliberate disregard of the high degree of probability that an emotional distress would follow. The common thread amongst the cases upholding the outrageousness prong is the shockingness of the statements given the unique circumstances in which those statements were made. It is my opinion that the trial judge will have to weigh whether or not some of the facts that fall within the Chapter 39 immunity would be relevant and admissible on retrial as they relate to Maya's IIED claims. When considering a claim for IIED, the facts of that specific case must be considered. Let's see. While I agree that some of the actions taken by Ms. Beatty, the nurses, and others related to J. Hatch are entitled to immunity under Chapter 39, and that the battery, false imprisonment, and medical malpractice claims cannot be used to meet the legal threshold for Maya's IIED claim, I also agree with the argument raised by Maya in her brief that Chapter 39 did not authorize or protect acts of intentional infliction of emotional distress, especially when committed by a healthcare provider to whom vulnerable people look for care. Emphasis added. And I believe that some of the information related to Maya's shelter and the dependency court's orders would be relevant and admissible to the extent that information is required to give the jury a full picture of the circumstances at the time. It is hard to imagine a civilized community that accepts the actions of Ms. Beatty, a licensed social worker, and the nurses as good faith participation in the requirements of Chapter 39. To be sure, J. Hatch makes no attempt to cast such a broad net to include these actions as privileged under Chapter 39, and in fact agreed at oral argument that the Chapter 39 immunity was not absolute. However, even after stripping Maya's IIED allegations of the offending claims and immunity entitled evidence, there remains competent, substantial evidence supporting the trial court's finding that Maya's IIED claim met the high bar of outrageousness. These healthcare providers were in charge of caring for and treating Maya. Instead, they exploited their positions with full knowledge that Maya, a 10-year-old child, would not be able to endure such outrageous conduct and undoubtedly suffer severe emotional distress as a result. The cases finding conduct outrageous are no different than the actions taken in the case. In fact, Maya's case, given her vulnerable age, paired with her special relationship as a patient under the care of Ms. Beatty and the nurses, is a more compelling one, which would cause an average member of the community to exclaim outrageous. Footnote 23. J. Hatch counters some of this evidence, but weighing the evidence against Maya's evidence is a jury question not to be resolved on a directed verdict motion, or, for that matter, in determining whether the alleged actions and statements met the threshold injury. In ruling on a motion for directed verdict, the trial court may not weigh the evidence or assess a witness's credibility and must deny the motion if the evidence is conflicting or if different conclusions and inferences can be drawn from it. For these reasons, I agree that Maya's IIED claim should be retried with the remainder of the counts. Opinion subject to revision prior to official publication. So that's it, folks. New trial for Maya Kowalski, Jack Kowalski, the estate of Beata Kowalski. That's bad news for them. That's terrible, terrible news. But bottom line, she at least gets to retry. Her IIED claim and the false imprisonment claim. And yeah, so that's terrible news for them. That's terrible news for Anderson and Glenn, LLP. That's just awful. They spent a lot of money on this case. Like a lot of money. I hope things go well. They've been working on this case for years. Several years before it went to trial, and it went to trial, I believe, in 2023. So this is crazy, but appeals take time. And like I said, the hospitals have money. They got lots of money. So, I mean, what do you do? What do you do? I mean, it's absolutely crazy. So I'm going to keep an eye out for more dockets coming out. We're going to go over this trial, I think, on this channel. The entire trial again, at least the most important parts, the most important witnesses. I think that'll be fun to do now that we know that we're going to have a new trial coming. That'll probably be coming in 2026, I would hope. Yeah, so hopefully things move along quickly because I'm kind of stoked for that trial now. Yeah, so happy Halloween, everybody. Thanks for checking me out. Thanks for joining us. I feel bad for the Kowalskis. This is awful news for the Andersons, Greg Anderson, Jen Anderson, Nick Whitney, all of them. So I'm going to check out. Thanks for watching. Don't forget to like and subscribe. And for those of you on Twitch, don't forget to follow. All right, guys, I'll be back on tomorrow morning, 11 o'clock, live stream, day 2, murder trial of a 6-year-old boy.